This is the LWA Torts Miscellaneous Concept Audio Outline. Intentional misrepresentation or fraud. 1. Misrepresentation of a material fact, not silence, but an affirmative statement. 2. Scienter. The defendant knew or believed the statement was false. 3. Intent to induce the plaintiff to act or refrain from acting on reliance upon misrepresentation. 4. Causation. That comes from actual reliance. 5. Justifiable reliance. And 6. Damages. The plaintiff must have suffered actual pecuniary loss. Negligent misrepresentation. The elements for negligent misrepresentation are 1. Misrepresentation by the defendant in a business or professional capacity. 2. Breach of duty towards the plaintiff. 3. Causation. 4. Justifiable reliance. And 5. Damages. This is typically limited to actions in a commercial setting. Malicious prosecution. The elements for malicious prosecution are institution of criminal proceedings against the plaintiff. The plaintiff was the defendant in that proceeding. Termination of proceedings in the plaintiff's favor. Absence of probable cause for prior proceedings, insufficient facts, no reasonable basis. Improper purpose was not to seek justice, and damages. Note, prosecutors are immune from liability. Abuse of process. The elements for abuse of process are 1. Wrongful use of process for ulterior purpose. And 2. Definite act or threat against plaintiff in order to accomplish the ulterior purpose. Interference with business relations. The elements are 1. Existence of a valid business contractual relationship with the plaintiff and third party or valid business expectation held by the plaintiff. 2. The defendant's knowledge of the relationship or expectancy. 3. Intentional interference by the defendant inducing breach or termination of the relationship or expectancy. And 4. Damages. Nuisance. Nuisance is not its own tort. It is a type of harm suffered. There are 2 types of nuisance, public and private. Private nuisance, substantial unreasonable interference with another person's use or enjoyment of property that she possesses or that she has a right of immediate possession. Substantial interference is the offensive, inconvenient, or annoying to an average member in the community. Unreasonable, the balance test. Severity of the inflicted injury must outweigh the utility of the defendant's conduct. Courts consider that people are entitled to use their property in a reasonable way. Trespass to land versus nuisance. Trespass to land, a physical invasion occurs. Nuisance, interference with use or enjoyment, can be intangible interference. Public nuisance, act that unreasonably interferes with the health, safety, or property rights of the community. The party may recover for public nuisance only if she suffered unique harm not suffered by the community as a whole. Nuisance remedies would be damages, which means monetary award, and injunction, only if there's a legal remedy or damages is inadequate or speculative. Defenses to nuisance include legislative authority, zoning laws permit the activity, contributory negligence, conduct of others. No one actor is liable for actions committed by the others. Coming to the nuisance. Cannot come to the nuisance and then initiate legal action if one's sole purpose for coming to the nuisance was to bring lawsuit. Generally, one may come to the nuisance and bring suit. Vicarious liability. Vicarious liability is liability that is derivatively imposed. One person commits a tortious act harming another, but we will hold a third person liable. Respondent superior applies to employee-employer relationships. Also see master-servant relationships. Employer will be vicariously liable for tortious acts committed by the employee if the act was committed in the scope of employment. Minor frolics and detours can be used here to hold the employer liable. Major frolics and detours cannot be used to hold the employer liable. Negligent hiring. This is not vicarious liability, but is related because it involves employers and employees. Employers may be held liable for their own negligence by negligently selecting employees or hiring or supervising employees. Independent contractor. The general rule for independent contractor is the principal will not be vicariously liable for tortious acts of his agent if the agent is an independent contractor. There are two exceptions. One, independent contractor is engaged in inherently dangerous activity, or two, the duty is non-delegable because of public policy considerations. For example, the duty to use due care in building a fence around an excavation site. Partners and joint venturers. Each is vicariously liable for the tortious conduct of another if committed in the scope and course of affairs in the joint venture or partnership. Automobile owner and driver. The general rule is the auto owner is not liable for the tortious conduct of the driver of his vehicle except unless the person driving is doing it for the benefit of the auto owner. The owner is the principal and the driver is the agent. Family car doctrine. The family car doctrine means liability for immediate household members driving a car with express implied permission. Permissive use. Some states impose liability where the driver had the owner's consent. Negligent entrustment. This is not vicarious liability, but it's related. An owner may be liable for his own negligence, not the driver's negligence, in entrusting the car to the driver. Other vicarious liability issues. Bailor for bailee of chattel. Bailor is not liable. Parent-child, general rule. No liability for acts of a child. Liability if the child is acting as an agent for the parent. And related, the parent's own negligence can lead to liability. Bars. The general rule is no liability for patron intoxication. Modernly, Dram Shop Acts. Liability to the bar for harm caused to a third party injured as a result of an intoxicated patron. Multiple defendant issues, joint and several liability, satisfaction and release, contribution and indemnity. Loss of consortium and services provided by the other spouse. Residual concepts in torts, survival and wrongful death actions. Tort immunities include intra-family tort immunities, governmental tort immunity, federal government and FTCA, state and local governments, immunity of public officials. This is not heavily tested. Review on your own. This ends the LWA Miscellaneous Concepts for Torts audio outline.